Alex here with part 133 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I would glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my exercise rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the appellate filings. This is going to be a video that doesn't really have a main paper. It's, for the most part, a lot of, I guess you could say, ancillary documents. It's really just going to be this way because the Supreme Court doesn't get past the filing fee portion of the appeal. I still have to go through it because, as I mentioned with part 0, I'm going to cover every single video, every single filing, every single paper in this case, and that includes this portion of the case, even though it doesn't really have much of an impact at all on the case. I suppose there are some lessons learned, and there is going to be some good commentary on the Supreme Court's order, but aside from that, my mindset going into it was a little nervous, especially seeing the judges order denying fee waiver, and then of course once we get the decision from the Supreme Court, I am definitely dismayed. In fact, I could say that if not for their intervention in Falcone v. Secretary of State, I would have lost all confidence in them, but because of that intervention, I kind of keep my mind focused on continuing the litigation process to protect our son, and it does succeed in the end, and they finally start to reverse decisions. A bunch of decisions in a row get reversed. So you guys haven't seen, I think, even a single one of those yet, but they are coming, and it will be serial reversals, just boom, 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 one after the other. Okay, in any event, let's go ahead and take a look at what I guess you could say I have filed, because I think the first thing we're going over is a motion for extension. So anyway, let's go ahead and take a look at what I have filed. Here we have the notice of potential dismissal for failure to pay filing fee. This is a standard. I think this is even automated. I don't even think that this is something the clerk actually deliberately sends out, but something that somehow, some way is automated by the Supreme Court's computer system. And anytime they don't have a filing fee, this document gets sent out. It gives you, I think, 10 days. I think I've always seen it give people 10 days, and that no action will be taken until filing fee is paid. Next document we have my motion for extension of time to pay filing fee, or in the alternative to proceed in forma pauperis. So I'm telling them, hey, can I get some extra time to get a response from the court, or in the alternative, can you at least give me forma pauperis status? So here is my motion. Standard introductory paragraph indicating that I'm representing myself filing this document in the Supreme Court. Going into the factual background, the district court denied my motion to modify child support on November 21st. I filed a notice of appeal on December 6th. The Supreme Court order directed that I pay the filing fee. Going into the argument, I cite Rule of Appellate Procedure 24 subsection A1, which states that if I need to get a fee waiver, I need to ask for it in the lower court first. To date, the Chief Judge of the Family Division of the 2nd Judicial District Court has not rendered a decision. The district clerk has advised me that the district court can take up to 60 days to render a decision on any submitted matters, which is an interesting way to delay the appeal. You know, usually the chief judge of the civil division responds to these very quickly. In fact, I'm not even sure if it was proper for this to go through this route. As far as I know, typically, ordinarily, fee waivers go through some specific judge who's like on call or on duty. In fact, I think it was a master, one of the domestic masters, that ruled on these. I thought the whole situation around this, where my judge ruled on it, was very disturbing, very odd, very irregular. Just because of my experience in the past in getting forma pauperis status, it always went to David Hardy, Chief Judge of the Civil Division. Anyway, let's go ahead. Well, I need to stop there. There is no civil division in Nevada. There's a family division, and then there's everyone else who is not in that division. Sometimes people get confused with that, including me. Next assertion is The time it takes the district court to render a decision would frustrate the purpose of the appeal. Even if the court does render a timely decision denying, I would still need extra time with which to submit the request to this court. Okay, next argument is alternatively, I'm asking this court to give me forma pauperis status, and then I go into my affidavit, which is probably going to just clone all of the other assertions on my income. So I'm not going to go through a copy-paste, guys. All of this, I'm sure, was mentioned. This one piece I want to highlight, though, the leftover income was needed to cover educational expenses and severe dental expenses for our son because my ex has refused to help pay and has burdened me with in excess of $3,000 in surgical expenses. So now that I know this is here, my full wrath can go into the Supreme Court's order denying. Now that I know that they knew about the $3,000 in surgical expenses, then I'm going to basically say what they did is unforgivable and actually facilitates and enables the district court to do things like this. This is a black eye on my opinion of the Supreme Court going forward. This is not something that I could remember, and I think I needed to go through the My Docket series myself just to see, how bad they can mess something up too. It's really, as I mentioned earlier, it's disillusioning. They've done a lot of things. I'm not going to say that they made it up. I'm not sure how you can make up the damage that you inflict on a child, but I can understand that they sometimes screw up just like any other judge. And I guess under the circumstances, I'm hoping that this is a mistake that they made because they didn't read the document and they just signed it. Though I'm not sure that that's going to be very comforting for members of the public and for my viewers to know that sometimes they make mistakes because they don't read documents. I think that if they actually did read and they denied it, it might actually be worse because that would indicate that, I just don't even want to think of that possibility. That's a worse situation, definitely. I'm going to go into... what they're basically saying is I should have paid the filing fee and not taken care of my son. That's what they're saying. Okay, let's go ahead and move on. Precedent, this is all the stuff I covered in the lower court's motion. And then here's my conclusion. Again, this is all copy-pasted from the lower court's request to proceed in forma pauperis. So none of this is new at all. Same thing here. It's just a conclusion. We got the certificate of service where I swear under penalty of perjury that this document was mailed to my ex, well, actually to my ex's attorney. And then we got my exhibits. These are all duplicates, guys. We went over the bank account, the unemployment insurance situation, the car, blue book, the student loan debt, and bill pay. So all of these things I've already gone through. As with my previous videos, my policy is to not go over documents that I've already gone through. But if you would like to review these for yourself, you can always do so by going down into the description below, clicking on the link, downloading the document for yourself, reading it. And if you see something that jumps out at you that you want to talk about, go ahead and post it down in the comments below. Now we have my motion seeking leave of the court to file an appellant's opening brief, or in the alternative, proceed as a fast-track child custody appeal. This is a curious situation. There were rules of appellate procedure that allowed fast-track child custody appeals to go into effect if you had an attorney. And if you didn't have an attorney, then you would have to go under the ordinary briefing process. And even then, you couldn't really file an opening brief unless you got permission. They wanted you to use their informal brief, which is just like some line paper that you write in with your hand, like handwritten. I didn't like doing that. One time I tried to file an opening brief and they got annoyed with me and said in the future I needed to ask for permission. So here I am asking for permission, which they will, I don't know if they'll grant because they're going to just dismiss for non-payment of the filing fee. In any event, let's go ahead and continue and go through this just to see what's in here. Gravamen is I'm trying to file an opening brief instead of using the informal brief. Legal analysis. With leave of the Supreme Court under Rule 46B, I can get permission to file an opening brief instead of using the informal brief. I don't think there is anything else in here except me saying, hey, I've done this before. Here's some cases you can look at if you're worried that I don't know what I'm doing. And then we go into the certificate of service, which is indicating under the rules of appellate procedure that I mailed this document to my ex's attorney. By the way, I think I said Rule 5 when I talked about the last document. Rule 5 only controls in all the other courts. For the Supreme Court, it's the rules of appellate procedure, not Rule 5 under the rules of civil procedure. They're two different sets of rules. Next, we have the notice of district court's order denying. Right here, I'm just letting the Supreme Court know that the lower court denied my request to proceed in forma pauperis. Now that they have denied this request, now the onus is on them to grant it or deny it. My declaration regarding the district court's order, I think I'm mentioning again that I would quit school to widen my availability. However, the entire purpose of the appeal is to determine whether or not a parent can be willfully underemployed for the purposes of higher education. Please read the concurrently submitted opening brief before deciding to order this. So I'm even warning them about the paradoxical situation. So this is just a dark day for my opinion of the Supreme Court. Probably the darkest. There are many decisions that they ruled against me on where I understood them. And to this day, I'm not really sure which justices signed those decisions because it didn't stick out at me as a serious issue. The justices that were involved in this order denying, I haven't forgotten. And I mean, I just hope that this is not something that they still do or that they're doing on a wide scale at the very least. I mean, I really do hope that they're reading this stuff. And if they are reading this stuff, I really do hope that they're not coming to these conclusions, especially in child custody cases, especially because those are the cases that are infuriating the public right now. Let's go ahead and move on into certificate of service. We have another rule of appellate procedure, certificate of service upon my ex's attorney. And we got list of exhibits, which contains the order denying from the court, which we already went over. Same thing. We're going to skip that. We don't go over things twice in the My Docket series. Order denying motion. Here is Justice Chief. This is the Chief Justice. Chief Justice Mark Gibbons is the one who signed the order. He reviewed the motion and he concludes that I am not indigent and that the motion is denied. I shall have 10 days within which to pay the filing fee or the appeal will be dismissed. So I need my viewers to understand this. The only way that I could have paid this was to take the money out of my son's surgery. And you know what's ironic is if my ex had agreed to pay her half, I would have had the money to proceed on appeal. So the only way that this worked, I mean, all of these negative things had to converge for this terrible conclusion to be reached. Number one, the judge in the lower court had to have a strong desire to rig this outcome. Number two, Justice Gibbons, for whatever reason, hopefully didn't read any of this stuff. I know that sounds bad. I hope he didn't read it and it's not his opinion. I hope that just some clerks put it together and he just signed it. If he did read it, my opinion is really messed up of him right now because the only other way for me to do this would be for my ex to pay those costs for the surgery or for me to forego the surgery and litigate the appeal. So yeah, this is pretty much going to be, at this point in time, this is the record for my my disillusionment of the Supreme Court. Nothing that they do from this day forward is worse than this. And for the most part, my opinion of them has been very positive ever since. In fact, had I not gone through this video in the My Docket series, I wouldn't have the memory. In fact, I mean, I couldn't really remember just how bad the situation was until I went over the realization that the only reason I couldn't pay those fees is because of the $3,000 that I had to put forth for my son's surgery. Going into the next document, we have declaration regarding financial status. So he's asking me to pay, and I'm trying to still tell him to understand that, I mean, this is just sad. It's a really sad situation. Certificate of service, same thing, serving this upon my ex's attorney and the court. And then they dismiss it. So he, I mean, again, same thing. Chief Judge Mark Gibbons. Same thing. And it's even, oh my God, and it's even mentioning. So I even had to put money into the child. It's just getting worse and worse. Compelled to retain counsel in the underlying action. Not only was I compelled to retain counsel, but I won. You know, I had to put, they shouldn't make you do that. They shouldn't make you. So anyways, guys, what I'm talking about here is the attorney that I hired for the upcoming modification hearing that I'm going to win on. This is the hearing that I keep mentioning is going to be the one that my ex is annihilated on, that I win on all 5 issues. It's the best, you know, outcome I have ever had in the entire court, not even just that court case, but the entire court system period. And then this website that he's referring to is our Nevada judges. Ugh, yuck. Yeah. Anyway, I guess that's it for this one. This case is not over yet. There will be, I think, one more video on the Supreme Court filing, and then nothing changes. They just double down on their decision. All that being said, let's move on. Going into the aftermath, I filed, let's see here, 4 documents. Those were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably, I'm going to just lump all of these documents into 15 minutes. I mean, none of these things require her to do any work. The only thing she's going to have to do is log them into her system, communicate them to the ex, and that's it. So I think 15 minutes, going at the rate of $250 an hour, and coming to $62.50 in attorney fees for my ex is pretty reasonable for this particular video in the My Docket series. As with my previous videos, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.